Let's take you back to our top story. Oscar Pistorius sentenced to 6 years in prison for murder. Joining me, attorney Marius du Toit. Thank you for your time this evening. Appreciate it so much. The judge said there were substantial and compelling reasons why Oscar Pistorius should not get the maximum sentence. What did you make of her reasoning in handing down the sentence?
I thought her reasoning was really cogent. I thought she dealt with all the factors relevant to arriving at the sentence. She set out the personal particulars, the seriousness of the crime, and of course the public's interest. And she dealt at length with the fact that the public had an erroneous belief, some quarters of them anyway, about the fact that this wasn't a mistaken identity or erroneous belief matter. This was in fact a spousal abuse. So I thought she dealt really well with all the factors that was necessary. And of course, in arriving at substantial and compelling reasons, I think it's the worst kept secret. I think everybody agreed that substantial and compelling reasons were definitely present to arrive at a lesser sentence.
This sentence, since it was issued around 11 a.m. this morning, seems to have split interested South Africans, those who've been watching this case from 3.5 years ago. Some believe it is just, others that it is just too lenient. Where do you stand?
I thought immediately when the judgment or the sentence was handed down, my first impressions were that it was a lenient judgment, but I thought it was right. I didn't think that it was a wrong judgment, that there is now suddenly room for an appeal by the state, or of course the defense, who would never appeal this. But my first impressions were that it was definitely a lenient judgment. I think everybody expected a sentence around about 10 years or 12 years or so, and this was 9 years less than the minimum sentence of 15 years. So it's definitely lenient, but I think the facts of this case have always been so peculiar and so bizarre that I think that it was always expected at the end of the day that the court would be bending backwards in order to impose a lesser sentence.
When we map the responses by people, especially if we just use social media as a barometer, there are people who are invoking the cases of Jub Marahanye, for example, culpable homicide. In that drag racing case, 4 kids were killed, 20-year sentence, and then later he got an 8-year sentence. There's a rhino poacher who in 2014 got 77 years for rhino poaching. So there are questions about the notions of justice and punishment in South Africa, and added to that is the whole issue of privilege, of wealth and access to the courts and justice. How do you answer people who invoke those cases alongside Oscar Pistorius' sentence?
Well, it's an argument well made, one has to say, but realistically speaking, each matter has to be considered on its own facts. You can't just generalize and say that because these cases are such, therefore it justifies a sentence of X, Y, and Z. If you look at the ballpark matters where people are charged with murder, generally speaking, they do get 15 years, unless the court finds something substantial and compelling. When you deal with, for argument's sake, drugs, you do find that the courts impose harsher sentences. It's the same with rhinos, which is, of course, a massive scourge at the moment being poached. So realistically speaking, one has to say that, you know, the court has to consider each case on its own merits, and that's exactly what Judge Masipa did here. Lenient so, but that's exactly what she did. And I don't think the public must get intertwined or confused by the fact that you want to compare rhino poaching suddenly with erroneous belief that I was being attacked by an intruder with drugs or whatever the case may be. So I just think one has to consider each case on its own factors and own merits.
But if you're talking about sending a message, and we'll be speaking to some of our reporters later who reflect, you know, that in murders in South Africa, I think it's around 20% of murders that actually result in a conviction. And when you look at a sentence like this, it's almost creating an environment or a perception that if you commit a murder in South Africa, A, you know, that there would be enough evidence to prosecute you and get the maximum sentence, and B, that if you can argue well enough, you'll get a minimum sentence, that you're not really going to be punished for a crime as deadly and as serious as murder.
Well, it's obviously an argument made, but I'm honest with you, I believe that in these circumstances, you have to say that it always justified a lesser sentence. I'm quite sure if you go to any magistrate's court in this country or any regional court and you go and draw their stats, you're going to find that for murder, the people do get 15 years or get 12 years or 13 years. So the benchmark is definitely not 6 years, but the facts of this case was just so unique and so bizarre. And of course, it was publicized worldwide, and that's why the public is latching onto it. But realistically speaking, the facts are just so bizarre. I mean, it never was a spousal abuse. Let me just qualify that, Iman. If Oscar had been convicted of killing Riva in the circumstances where there was an argument beforehand or something to that effect, we would have sit here today and we've had a 15-year or 18-year sentence easily. But it's just because it was never the case that he was going to kill Revo. It was always a case that he thought he was killing an intruder.
Let's talk about the state's next move. The jury, well, I mean, the jury, we don't know yet whether they're going to mount an appeal. What do you think their prospects might be? They won in the SCA last time round in overturning the culpable homicide conviction.
Well, the first step, of course, is they have to go back to Judge Masipa within 14 days, and they have to lodge a notice of application for leave to appeal, wherein they'll set out their grounds, and Judge Masipa would have to consider it. I can't see her whatsoever even granting them leave to appeal, because she will definitely not say that there's a prospect of success on that aspect. You remind yourself, first time around when the matter went to the SCA, she also denied them leave to appeal against the sentence. She only allowed them against the conviction. Going to the SCA, of course, you have to show with a petition 21 days after it's been denied, after your leave to appeal is denied, that you have once again a reasonable prospect of success.
To go directly.
And of course you have to show special circumstances in the Supreme Court of Appeal, which is maybe easier to find the Loch Ness Monster sometimes to prove special circumstances. So I would say that I somehow think we've reached the end of the road in this matter.
Marius du Toit, thank you very much for your analysis. We appreciate it giving us his take on the Oscar Pistorius sentencing.